in the matter of application by Martina Dillon, John McEvoy, Brigid Hughes and Lynda McManus for judicial review.
Yes, Mr. Larkin.
Good morning, my Lords. My Lords, by my arithmetic, which yields, of course, to the superior arithmetic of the court, we have 70 minutes this morning, and that's based on the extra 50 minutes taken by the Secretary of State and subtracted by the 55 minutes that Lord Wilson took instead of his 4 hour.
Mr. Bunting started at 11:26 yesterday instead of 11:15. Yes.
Thank you, my Lord. There's quite a bit to get through, and in ease of the court, we have uploaded to the portal a note, which, among other things, deals with the question raised by my Lord Stevens yesterday about the origin of the instruments in Annex 1.
I'm afraid, Ms. Larkin, we don't accept speaking notes.
There are hard copies there. It might be of assistance, certainly, even if the court disregards everything else except the part that deals with the question raised by my Lord Stevens.
Well, if you want to address us on it, you can address us on it.
Yes. Oh, very well, my Lord. The route map then for this morning's submissions consists of 6 parts. Firstly, I'll finish off the external aids to the interpretation of the Article 2. Secondly, I'll look at the section RSEO of the Belfast Agreement. Thirdly, I'll look at the Victims Directive. Fourthly, we'll look at how the SPUC test was handled by the High Court and Court of Appeal. Fifthly, we'll look briefly at the question of disapplication. And then sixthly, I'll address the cross appeal and the applicability of the Charter of Fundamental Rights. So, yesterday I'd finished the explainer, and the third and final instance of state practice that we wanted to draw to the attention of the court was the letter from the Northern Ireland office of the 26th of February, and that's quoted in the judgment of the Court of Appeal at EF 376 going to 377. So it's contextualised in 376 and then quoted in relevant part.
Sorry, this paragraph 376?
No, page.
No, it's page 376 going to page 377. It's paragraph 72. Page 376 contextualises the extract, and the quotation is on 377, and the Court of Appeal has added its emphasis.
Do we have the letter in the bundle?
No, we don't. We do. As my Lord will see, it's addressed to Professor McCrudden, and no doubt he may touch on the specific origins of that correspondence.
Does the Court of Justice of the European Union take into account subsequent practice of states in interpreting treaty obligations?
Yes, it does, because the Vienna Convention requires it to do so.
Well, where is the authority in which it has done so?
Well, we'll have to revert to my Lord on that, but it is...
your principle is that this is a matter of union law. You look for union law to how that is administered by the Court of Justice of the European Union, and you haven't referred to, as yet, any case in which the Court of Justice relies upon practice of states.
Well, It seems...
That's the basis on which, is that the basis on which we're being asked to look at this letter?
Yes, that it's an example of state practice, and to which the Vienna Convention applies.
Yeah.
Does it? It's about practice in the application of the treaty. Had the treaty taken effect when these documents were produced, including the explainer?
No.
No. Well.
But it's an indication of how it's going to be put into practice.
How can you bring it within Article 31 of the Convention if it predates the taking effect of the treaty?
Well, it is an expression by one party to the agreement, the United Kingdom, again in the context of the duty of cooperation in Article 5 of the withdrawal agreement, that this is how it intends to put the agreement into practice. We've drawn attention also to Article 165 of the withdrawal agreement, where there is an emphasis on both the Union and the United Kingdom agreeing the interpretation.
But it's the temporal point I'm making. The Vienna Convention seems to be looking at the behaviour of the parties after the treaty has taken effect. So I don't think you can bring it within that. Are you trying to bring it within the context in which the treaty was signed?
Well, certainly its context is a broad enough concept to embrace that in any event. So if it doesn't fall within 31.2, then it certainly falls within context. We say inescapably a matter which goes to the context of the agreement between the United Kingdom and the European Union.
Mr. Larkin, the provision in the Vienna Convention is concerned with interpretation, and it occurs to me that I wonder to what extent we are concerned with the question of interpretation. The question as to whether a provision has direct effect or not is going to be decided by EU law on direct effect, isn't it?
Well, yes, well, respectfully, of course, that is correct, but the context within which one decides whether or not direct effect exists is to be obtained from the words used in their context, and the context we say is supplied by this letter, by the explainer, and by the amendments that were effected to the Northern Ireland Act, some of which we drew attention to yesterday. And I'm grateful to those behind me who assisted me with chronology. So the agreement and protocol were agreed on the 17th of October 2019. It was signed on the 24th of January 2020. It came into effect just after midnight on the 1st of January 2021. And the letter is dated, as I've indicated, the 26th of February 2020. And the letter is fully in the papers. It's not just extracted. So it's at 1068. So we say that nothing in this should be regarded in the least now as surprising, and while of course nothing in this can foist an interpretation on this court that it is unwilling to accept, we say the unchallenged state practice and context as seen by these documents and by the enactments of Parliament give a clear steer as to interpretation, which we respectfully commend to the court. I now want to ask the court to look at the RSEO section of the Belfast Agreement, and the court will find that at page 10842. The first sentence is the most important, with its tripartite emphasis. That's at 10842. Tripartite emphasis on mutual respect, civil rights and civil liberties. But this particular rights commitment is buttressed by 4 other references, in the British-Irish Agreement itself, and 3 in the multi-party agreement. And it will not have escaped the attention of the court that the version that we're referring to is the treaty series version, and this is part of the annex to the British-Irish Agreement. So the first passage that I want to draw attention to is in the British-Irish Agreement itself, and it's at page 10816. And this is 1.5 of the British-Irish Agreement, and we draw attention to the reference to that whatever choice is freely exercised by the majority of the people in Northern Ireland, the power of the sovereign government with jurisdiction there shall be exercised with rigorous impartiality on behalf of all of the people in the diversity of their identities and traditions, and shall be founded on the principles of full respect for and equality of civil, political, social and cultural rights, of freedom from discrimination, and of parity of esteem and just and equal treatment for the identity, ethos and aspirations of both communities. That finds an echo in the Declaration of Support, which is at page 10822. We firmly dedicate ourselves, this is the second sentence, we firmly dedicate ourselves to the achievement of reconciliation, tolerance and mutual trust, and to the protection and vindication of the human rights of all. Also in the constitutional issues, the next page, 10823.
Sorry, at 10822, the second sentence of
1, 2. So the paragraph beginning, the tragedies of the past. In fact, it's the third sentence, but we shall best honour them through a fresh start. The third reference then is in the next section at page 10823, entitled Constitutional Issues, and it's paragraph 1.5, paragraph 1, subparagraph Roman 5. And the last part of that, the power of the sovereign government with jurisdiction there shall be exercised with rigorous impartiality on behalf of all of the people in the diversity of their identities and traditions, and shall be founded on the principles of full respect for and equality of civil, political, social and cultural rights, freedom from discrimination for all citizens, parity of esteem and just and equal treatment for the identity, ethos and aspirations of both communities. And finally, in Strand 1 at 10827, this agreement provides for a democratically elected assembly in Northern Ireland which is inclusive in its membership, capable of exercising executive and legislative authority, and subject to safeguards to protect the rights and interests of all sides of the community. So the notion of a commitment to rights is mutually reinforced by a number of provisions, not only in the multi-party agreement, but in the British-Irish agreement itself. And we respectfully commend the analysis of this given by the Court of Appeal at paragraphs 114 to 122 of its judgment, at pages 392 and 394. And we say that the relevant content of RSEO is determined by the EU underpinning as at the 31st of December 2020, just before the protocol and the withdrawal agreement as a whole comes into force. We remind the court respectfully of our image that the RSEO section is a container, and the dimensions of the container are set out in RSEO in 1998, but the content of the container is not settled for Article 2 purposes until the end of 31st of December 2020. And we draw attention to the interplay between, we've already seen, of course, Article 2 of the Windsor Framework, but I draw attention to two further passages very briefly in the Windsor Framework. The 6th recital at 10749. Noting that union law has provided a supporting framework for the provisions on rights, safeguards and equality of opportunity of the 1998 agreement. Finally, within the Windsor Framework, to Article 2.3 at page 10751. This protocol sets out arrangements necessary to address the unique circumstances on the island of Ireland, to maintain the necessary conditions for continued North-South cooperation, to avoid a hard border, and to protect the 1998 agreement in all its dimensions. So, can I then move to the topic of the Victims Directive? And the court will find that beginning at page 5584. And we draw attention to some of the recitals. So if one begins firstly by looking at the recital 3, where the root of title of the directive is set out, and we've already seen Article 82.2 provides for the establishment of minimum rules with regard to the, among other things, to the rights of victims of crime. We draw attention to recital 12, to the broad definition of offender. This is at page 5585. The rights set out in this directive are without prejudice to the rights of the offender. The term offender refers to a person who has been convicted of a crime. However, and this is important, my lords, for the purposes of this directive, it also refers to a suspected or accused person before any acknowledgement of guilt or conviction, and it is without prejudice to the presumption of innocence. And that, we say, is of particular relevance to the content of Article 16, as we shall see presently. Recital 16, at the bottom of that page, 5585, makes particular reference to victims of terrorism, and the court will wish within that 16th recital to note particularly the end. Member States should therefore take particular account of the needs of victims of terrorism and should seek to protect their dignity and security. Moving from the recitals, although we will return again to the recitals in the context of Article 11.5, we draw attention to the definition of victim at 5592, and pause to simply ask the court to note that and to note the obvious point that all of the respondents are victims for the purposes of this directive.
The definition is in Article 2, yes. Thank you.
It is. Yes. And all of the respondents are victims for the purposes of the directive. Can I invite the court to go forward to Article 11 at 5596, rights in the event of a decision not to prosecute. And we draw attention here particularly to the distinction in Article 11.1 between the first sentence and the second sentence. First sentence, member states shall ensure that victims, in accordance with their role in the relevant criminal justice system, have the right to a review of a decision not to prosecute. The procedural rules for such a review shall be determined by national law. The substance of the right is directly effective. It can be relied upon by someone who is a victim of crime. True it is, however, that the particular modalities by which that right may be exercised is a matter for implementation, subsequent implementation, necessarily by national law. So we rely on the first sentence in paragraph 1, subparagraph 1 of Article 11, and we say that presupposes the possibility of a prosecution, and it is incompatible with the immunity that is established through the combination of Section 19 of the 23 Act. Just for the Court's note, that's at 5278. The Court was taken to it yesterday. Section 38, the bar on investigations other than through the Commission. That's at 5319. And then Section 41, in many ways a hugely important and baleful provision, we say. That's at 5323. That is the provision which prevents prosecution for such offences as conspiracy to murder, attempted murder, possession of firearms with intent to endanger life, possession of explosives with intent to endanger life, causing explosion. So the state might well be left to establish the modalities for the exercise, but the state cannot take away the substantive right, and the state has taken away the substantive right with respect to the 4 respondents in this case. Now, reliance was placed by counsel on behalf of the veterans on Article 1.5, which is also page 5596, which says that paragraphs 1, 3 and 4 shall not apply to a decision of the prosecutor not to prosecute if such a decision results in an out-of-court settlement insofar as national law makes such provision. And we say that is of no assistance for 2 reasons. Firstly, the immunity provisions are not activated or triggered by a prosecutor. So that suffices in itself. And in any event, if one goes back to the recitals and to 5589 and to recital 45, a decision of a prosecutor resulting in an out-of-court settlement and thus ending criminal proceedings excludes victims from the right to a review of a decision of the prosecutor not to prosecute only if the settlement imposes a warning or an obligation. And of course, the immunity provisions in this case impose neither a warning nor an obligation. So insofar as 11.5 is relied upon, it's incapable of having the effect claimed for it for the 2 reasons that we've discussed. Can I ask the Court then to look at Article 16, which is at page 5597. Member States shall ensure that in the course of criminal proceedings, victims are entitled to obtain a decision on compensation by the offender within a reasonable time, except where national law provides for such a decision to be made in other legal proceedings. Member States shall promote measures to encourage offenders to provide adequate compensation for victims. Section 43, of course, is utterly antithetical to that. It excludes all claims of tort and delict. And there is no possibility of compensation from the offender. The removal of the possibility of criminal proceedings takes away entirely the possibility of a compensation order being made. The court knows that is sometimes made in criminal proceedings. And the parallel operation of Section 43 means that with the extinguishment of all possibility of civil actions, Article 16 is breached. There is sadly very little assistance on any aspect of the directive from the Court of Justice of the European Union, but there is one decision that we found that looks at Article 16, and it's the decision in Gambino, and we draw attention to three passages in Gambino. Paragraph 28 at 8884 shows, we say by necessary implication, that it was plainly accepted that Article 16 had relevantly direct effect in the member state, Italy in that case, but usefully in the context of the cross-appeal on the Charter, one sees that its direct effect is tempered by the Charter provisions, Articles 47, 48, and one sees that in paragraphs 39, 40 of Gambino at page 8885.
So what's the paragraph numbers again, sorry?
It's paragraph 28 is 8884, and paragraphs 39 and 40 are 8885.
Paragraph 28 sets out the question referred.
Yes. And that's why we say by necessary implication, because there's no suggestion that, surely this couldn't possibly have this effect. What we have is the Italian court actually giving, in the event, a much more generous, at least to the potential victim of crime, interpretation of Article 16, and the court in terms saying, not so fast, the accused, the two accused are entitled to a hearing of that witness before the reconstituted panel, if the panel is reconstituted, or these are the persons who will be making the decision on guilt or innocence. Hence, the Charter is used to inform the interpretation and application of the directive. That's obviously a position, as the court will see, that the Court of Appeal agrees. The Court of Appeal is content for the Charter to have that interpretive effect. We say that there are examples of where it goes much further than that. So I am going to ask the court to look at the SPUC test as it was dealt with in the High Court and Court of Appeal. Happily, for our purposes, we need look only at the judgment of the Court of Appeal. So the SPUC test is set out in paragraph 94 of the Court of Appeal judgment at page 385. The six-part test, and there is an indented quotation at page 385, paragraph 94 of the Court of Appeal judgment. If we go forward to paragraph 96 at 386, we see from indented A to F the way in which those tests or criteria were applied by Mr. Justice Colton. And then we see the Court of Appeal's own approach to that, beginning at paragraph 114 at page 392 and going on to paragraph 135 and page 397. The Court has read that, and the Court will doubtless read that again. I draw attention this morning only to paragraph 127 at 395, simply to illustrate a point which arose in exchanges yesterday. Obviously included within the rights, safeguards and equality of opportunity container, that is, the contents of the container include not only rights underpinned by EU law, but rights underpinned by the Convention, rights given effect perhaps by other international obligations, and by domestic right conferring provisions. But what matters for the purposes of the applicable tests, whether it's the test in the three-part test in the explainer or the SPUC test, is what it ultimately is the EU underpinning. And the thought experiment question is, could this have happened during the currency of the United Kingdom's membership of the European Union? And we say whenever that thought experiment is applied, a resounding no is returned as the inevitable answer. The key reason for drawing attention to 127 in the first sentence is the finding by the Court of Appeal, by contrast, the Convention rights cannot, in our view, said the Court of Appeal, be said to have an EU underpinning. If I can then turn very briefly to the issue of disapplication, and it's perhaps useful in that context perhaps to try out what we've described as the thought experiment again. So had this litigation occurred during the currency of UK membership of the European Union, could it have happened? No. If our submissions had been upheld by this court and the issue of remedy came to be considered by this court, again, one emphasises during the currency of European Union membership, would there be, one asks rhetorically, but hopefully with more than rhetorical effect, any doubt but that disapplication of conflicting national legislation would be the appropriate remedy in the circumstances? Two quick supplementary points. Firstly, is it possible to hold things up temporarily, as it were, to keep the lights on? Yes, of course it is. And we make reference to A and others, and the relevant part is at the operative judgment. Part of the order of the Luxembourg court is at 8415. But this is not a case where it's a question of keeping the lights on, nor is it a question of where the court is required to fashion a scheme-like remedy. The remedy is simple disapplication of conflicting provisions of national law, and the lawful position, we say, is simply the status quo ante. So, can I then turn to the cross appeal in the time available to me, and can I firstly address a point that was made on Tuesday by my learned friend Dr. McLean. He drew the attention of the court to section 5.4 of the Withdrawal Act, saying that the Charter doesn't apply, or at least was a strong indicator of parliamentary intention that the Charter was not intended to have a role, and one sees that at page 5119. So he took you to section 5.4, but crucially, the court was not taken to 5.7, which is on page 5120. And subsection 7 says subsections A1, 11.6 and Schedule 1 are subject to relevant separation agreement law, for which see section 7C. And 7C is at page 5130, and subsection 3, relevant separation agreement law means, for our purposes, A, any of the following provisions or anything which is domestic law by virtue of any of them, Roman 1, section 7A, 7B, 8B or BC, but importantly section 7A. Now, already, and it seemed the learned friend was disposed to accept this, that there was a tension on the face of things between 7A and what we've described as its steamroller domestic effect. But in fact, one doesn't simply have to let the steamroller operate. There's a reconciliation between 5.4 and it's achieved by 5.7 and 7C. So 7A is able to operate freely.
Mr. Larkin, I'm sorry for taking you back to something which you thought you passed. I'm having a little difficulty understanding the. I mean, it's not a criticism of your submissions, but I'm having a little difficulty understanding the approach laid down by the Court of Appeal and SPUC as set out in paragraph 94. Can I just ask you about that? It's on page 385. I don't want to see if
yes. Well,
you can help me to understand this. Yes. So Roman 1, so you have to satisfy the 6 elements. Roman 1, a right included in the relevant part of the Belfast Agreement is engaged. Yes. So just, for example, take the Victims Directive. So a right protected by the Victims Directive is engaged. Yes. Roman 2, that right was given effect in Northern Ireland before exit day. Now, given effect, when you look at Roman 3, it refers to that Northern Ireland law. So I think given effect must mean given effect in law.
Yes. Helpfully, the Court of Appeal addresses that in some detail and cites useful authority from the CJEU. It cites the Marks and Spencer's case, because candidly, if one was put to it and said, now, does the Victims' Charter fully bring into effect all of the rights in the Victims' Directive? No, of course it doesn't, Lords, it doesn't. But it doesn't have to, because Northern Ireland law for this purpose means the directly effective rights that can be relied upon by citizens in Northern Ireland, or rather than making a tendentious submission, during the currency of UK membership, could citizens in Northern Ireland have relied directly on the directly effective parts of the Victims' Directive?
And it may be that this test isn't really apt here, but the point you just mentioned sort of illustrates the problem. The tests are predicated on there being domestic legislation in Northern Ireland implementing EU law, as I understand it.
And that's why the court recalled yesterday that we expressed ourselves content with modifications of the approach in the explainer in paragraph 10, the three-part approach. That there are, and indeed as one sees, and the court will probably wish to look again in some detail at the way in which the Court of Appeal handles this. But it might be thought that the proper approach is for there to be some consolidation and slimming down of the SPUC test.
Yes.
And that's why, in many ways, what I described as the thought experiment. Could this have happened but for the UK leaving the European Union? Or could it have lawfully happened but for the UK leaving the European Union?
So we're not really in territory where we have, in the present case, a right given effect by implementing legislation in Northern Ireland underpinned by EU law.
There is the pretty soft law, as the court will have seen, of the Victims' Charter, but yes.
And when you come to Roman 4, has the underpinning been removed? Your point really is that it hasn't, isn't it?
Well, it can't lawfully have been removed. So if one takes the directly effective rights under the Victims' Directive, they cannot, as a matter of law, have been removed. Yeah. But they have been purportedly removed. And again...
simply by enactment of a provision which is inconsistent with them?
Yes.
Right. So... I see.
So again, that's why what we've described as the thought experiment is useful. So the question is, could this have happened during the currency of UK membership? Could something have happened which is utterly incompatible, we say, with Article 11.1 of the directive, with Article 16.1 and 2 of the directive? We say, no, of course not. And that's even before one gets to the Charter.
I think I understand your submission it's better than I understand.
I'm very grateful to my Lord for that clarifying question. Most grateful. So we're then beginning to look at the cross appeal, and having addressed the issue under Section 5.4 of the Withdrawal Agreement Act, and turning then, and it's worthwhile to emphasise that, of course, the Court of Appeal is quite right to emphasise the interpretive force of the Charter. It was wrong, however, respectfully, we say not to acknowledge that the Charter is capable of being relied upon by itself. And the starting point is Article 51.1, which is at 5583, and see that the provisions of this Charter are addressed to the Member States only when they are implementing Union law. 51 paragraph 2 confirms that the Charter doesn't extend the field of application of Union law beyond the powers of the Union, or establish any new power or task for the Union, or modify powers and tasks as defined in the treaties. The issue then is what is meant by implementing, and we say that we have helpful doctrine articulated by this court in Rugby Football Union. Paragraph 28 of that case at page 7968. Lord Kerr held that implementing EU law is to be interpreted broadly, and in effect means whenever a member state is acting within the imperial scope of EU law. And essentially I'm going to deal with the cross-appeal by reference largely to two fairly recent cases, both Grand Chamber decisions of the Luxembourg Court. And before inviting the Court to take up consideration of those cases, we say that, in one sense, it is our submission that, and this case illustrates the point, I trust, the Charter applies most significantly and usefully, perhaps, when the requirements of union law are less being honoured than when they are being defied. And that is why the concept of scope is so particularly useful. So I'm going to ask the question, if one takes any right in the Charter and the state is acting to give respect to that in the context of a larger European Union competence, then typically very little difficulty will arise. The difficulty will classically arise, and this case illustrates it, when the state, in fact, is not, is certainly working in the sphere, the scope of union law, but in fact is very definitely not, in a technical sense, putting EU law and principles into practice. And a very useful authority, we say, making that point good, is the decision of August this year, Grand Chamber decision, both on this aspect of implementing and on the use of the Charter as a source of justiciable rights, is the Royal Football Club Serang case. And that starts at page 10177. And quite a complex history, as often the Luxembourg cases tend to have. So Royal Football Club Serang came off second best in FIFA arbitration before the Court of Arbitration for Sport and the Swiss Federal Supreme Court. Belgian law gave the effect of res judicata to the Court of Arbitration for Sport as between the parties to the arbitration, and it gave probative value to the award as respects third parties. And having lost before the Brussels Court of Appeal, Serang came before the Cour de Cassation, which referred the questions to the Luxembourg Court, and these are set out at paragraph 59 at page 10183. And one can see there what the question is. Does Article 19, read in conjunction with, that's the jurisdictional provision, and Article 47 of the Charter, preclude the application of provisions of national law, such as Article 24 and Article 17 of the Judicial Code, laying down the principle of res judicata to an arbitral award, the conformity of which of EU law has been reviewed by a court of a state that is not a member state of the European Union, which is not permitted to refer a question to the Court of Justice of the European Union for a preliminary ruling. So, if one pauses there, the Belgian courts, except possibly for the Cour de Cassation, were certainly acting within the scope of Article 19(1) TEU, but they were only implementing it if implementation can include the concept of obstruction. So, again, one can further observe, we say respectfully, that the real value of any rights protection, such as the Charter, arises from its intervention to prevent or make good a breach of rights rather than when things are going well. So we draw attention to paragraph 118, which is at page 10187.
Sorry, paragraph?
Paragraph 118 at page 10187. And there, the Grand Chamber says this, paragraph 118. Lastly, it must be borne in mind that according to settled case law, Article 47 of the Charter, which is the equivalent of Article 6 of the Convention, is sufficient in itself and does not need to be made more specific by provisions of EU or national law in order to confer on individuals a right which they may rely on as such. And then there's reference to Eggenberger and Toberoff and so on. And that's referenced as well in paragraph 122 over the page at 10188. The last sentence, it is important to point out in that regard that it is the very conferral of such an authority and consequently such a value on the arbitral award that in such a context is in breach of the requirement of effective judicial protection referred to in the second subparagraph of Article 19 TEU and in Article 47 of the Charter. So we say, true it is, of course, that there is overlap between Article 19 TEU and Article 47 of the Charter, but the Grand Chamber in Serang, as we've seen, doesn't treat Article 47 as merely going to the interpretation of Article 19 and emphasises in paragraph 118, again page 10187, that Article 47 is sufficient in itself. And we say that is Grand Chamber authority, recent Grand Chamber authority, confirming, really putting it beyond doubt, that the Charter has a free-standing application. Now, we say that it's clear that obviously the Court of Appeal couldn't have had the benefit of that Grand Chamber decision, and we say if it had, then it would, we respectfully suggest would have agreed with us in our contentions on the Charter. Also useful, a decision which was considered by the Court of Appeal is another Grand Chamber decision is CG, and CG starts at page 8714. And the Court will see that in CG the United Kingdom argued, and that's set out in paragraph 53 at page 8753, that the case was governed by national law because the temporary right of CG was granted on the sole basis of national law. Now, the decision might be thought to contain reasoning that is not always straightforward and easy to follow. But as far as one can judge, the approach of the Court is to really begin the breadcrumb trail to its outcome at paragraph 57 at page 8753 by saying there that because CG made use of her union law rights to move freely, his or her situation falls within the scope of union law. Again, the emphasis there is on what the citizen does. So it's what the citizen does brings her behaviour within the scope of union law. Now, that breadcrumb is next followed by another breadcrumb in paragraph 84 at page 8757. And there, having referred to, well, firstly, 87 is an important paragraph because 87, as it were, makes it very clear that the UK has gone beyond the directive that was thought to be in play, that was Directive 204/38, and therefore, having gone beyond it, the action of the state cannot be regarded as an implementation of that directive. Then it is said that it's by contrast that the recognition of the right of a member state to reside freely on its territory is then a matter of some legal significance, because in 87, paragraph beginning, it follows that. Now, there might be a certain scepticism as to whether it follows at all, but nonetheless, this is the train of argument adopted by the court.
87?
Paragraph 87 at page 8758. So it follows, the words with which paragraph 88 begins, that where they grant that right, so we've moved from recognising it in the preceding paragraph to granting it, in circumstances such as those in the main proceedings, the authorities of the host member state implement the provisions of the TEU Treaty on Union Citizenship, which is pointed out in paragraph 62 above, is destined to be the fundamental status of nationals of the member states, and that they are accordingly obliged to comply with the provisions of the Charter. There is then a discussion of Article 1 of the Charter, Article 7 of the Charter, which corresponds with Article 8 of the Convention, and a reference to 91 to children and dignified conditions. And it's when one looks at the actual answer to the referred question at paragraph 93 that one sees how EU law really doesn't have terribly much to do with things, because if one looks at 93 at the letter C, however, provided that a union citizen resides legally on the basis of national law in the territory of a member state other than that of which he or she is a national, the national authorities empowered to grant social assistance are required to check that a refusal to grant such benefits based on that legislation doesn't expose the citizen and the children to an actual and current risk of violation of their fundamental rights as enshrined in Articles 1, 7 and 24 of the Charter. It certainly adopts what we say is a very expansive approach to the concept of implementation, and of course there one sees the entirely freestanding reliance upon the Charter as a means of delivering rights to the citizen in that case. So I won't take the court to what we address the way in which the Court of Appeal tries to distinguish or to not have proper regard to CG. That's addressed in our printed case, and we draw attention to that, and the court will have seen our printed case. But the importance of these cases is twofold. One, in terms of a practical problem-solving approach to the meaning of implementation. Again, we respectfully remind the court of the value of Lord Kerr's formulation in Rugby Union as to scope, and also as demonstrating really beyond any possibility of rational contradiction. We respectfully say that the Charter can be relied upon independently. Now, it's here when one looks at the interplay between the Charter and the Convention. We know that the Convention has the interpretive lead in relation to Charter articles which correspond to those within the European Convention on human rights. And that much is clear, again, from the Charter itself. The rights on which we rely are Article 2 of the Charter, which corresponds with Article 2 of the Convention, Article 4, which corresponds with Article 3 of the Convention, and Article 47, which, as we've seen, corresponds with Article 6 of the Convention. Happily, given the overlap with those Convention articles and the submissions that the Court heard yesterday from an learned friend, Mr. Bunting, I don't need to dilate on these. These are to be interpreted in the light of the Strasbourg jurisprudence. And they go, firstly, to the interpretation of the victims' rights, so that the Victims' Charter, the Victims' Directive, again, quite apart from what we say are its clear words giving direct effect, is to be interpreted as utterly inconsistent with any form of state immunity or amnesty, but also on a freestanding basis, given that we are clearly, it really hasn't been seriously suggested otherwise, that the state, from a number of perspectives here, is implementing EU law, certainly in that expanded sense, certainly is in the scope of union law, that the Charter applies also as a freestanding source of rights. True it is, of course, and Mr. Justice Colton was criticised for dealing with the matter somewhat elliptically, breach of the Convention, ergo breach of the Charter, but properly understood, it's not that, and we certainly do not maintain that a breach of the Convention is to be equated ipso facto with a breach of the Charter, save where the Charter is applicable. Where the Charter is applicable, and we say it's clearly applicable here, then the breach of Article 2, 3 and 6 of the ECHR must lead, we say, inevitably to a breach of Article 2, Article 4 and Article 47 of the Charter of Fundamental Rights. I've actually kept the original time, but can I, if the Court would give me a moment, because I would like to look and see if I can address fully. We certainly have in writing, but if I can even give a short synopsis of the position with respect to the Annex 1 provisions that. Yes, I'm grateful to our learned friends. As we observed yesterday, 5 of the 6 instruments in Annex 1 post-date the 1990 agreement because they are in 2004, 2006, 2000, 2000 again, and 2010 respectively. Council Directive 2004-113 EC of December 2004. The proposal, as appears from recital 6 to 7 of the directive, was only reached in the second millennium, that is after the 1990 agreement. So it's entirely a fresh instrument. 2000 Directive 2043. That's the equal treatment on the grounds of racial or ethnic origin. It didn't update or replace any pre-existing directive, and it emerged following a Commission proposal in December 1999, i.e. after the 98 agreement. Council Directive 2078 established a general framework for equal treatment in employment and occupation. It too didn't update or replace any other directive that predated the 1998 agreement, and Recital 2 records the fact that the principle of equal treatment was well established by a body of EU law, in particular Council Directive 76/207, and so that deals with the five. So I trust that.
I started a hair running. I apologize.
Well, no, it's potentially a very important hair indeed, my lord. I'm grateful. Can I, before sitting down, subject to any issue that the court may wish to raise with me, just draw attention to, and the court needn't turn it up, to Article 4.1, just in terms of direct effect, and to emphasise that direct effect is, firstly, it's a concept of union law, so it's made applicable to the terms of the withdrawal agreement itself, and the provisions of union law made applicable to it, and therefore the reference to direct effect in the second indent of 4.1 must be referred back to that broader concept in Article 4.1 of the withdrawal agreement. My lords, I recall some very I think it was John Marshall Harlan before the United States Supreme Court finishing a little early, and one knows how very austere that court is with time limits, and he famously said, I make the court a present of 5 minutes. May I make the court a present of 5 minutes?
Always gratefully received.
Thank you.
Thank you very much, Mr. Larkin. Is Mr. Crudden?
Thank you, my lord. May I first thank the court for permitting the Equality Commission for Northern Ireland to make written submissions and indeed oral submissions in the case. In the short time available, I would like to assist the court on the issue that my Lord President, Lord Reid, raised with Mr. Larkin concerning the origins and status of the explainer document, which, as you know, is interpreting Article 2. My Lord, we consider this issue to be of such importance that I'll devote, I think, probably all of the time available to me in attempting to assist the court on this issue. However, since I wrote my notes, a couple of issues have arisen on which I perhaps might assist the court on that have arisen in the last few minutes. And the first is the issue that my Lord Lloyd Jones raised about the question of the subsequent practice being used by the Court of Justice in the interpretation of agreements. I'm sorry, Lord Stevens, my apologies. And in that context, you asked, my Lord, whether there was case law specifically on that. In the limited time available that I've done some research, my Lord, the case that seems to strike your point is the Anastasio case, which is case C43292. And in that case, which concerns the interpretation of the association agreement, my Lord, I'm afraid we do not have a copy of the judgment, which concerned an association agreement between the EEC, as it then was, and Cyprus. The court said at paragraph 43 that it noted, in accordance with Article 31 of the Vienna Convention, quotes, substantial importance properly attaches to the objective and purpose of a treaty. That's sort of obvious, my Lord, and many other cases have done the same. But then it goes on to say, and any subsequent practice in its application. and this is at paragraph 43. Now, I must be candid with the court. The court then went on not to apply that in the context of the interpretation of the association agreement, because it considered that the text of the agreement was quite clear in that case. But my suggestion, my submission, my Lord, is that paragraph 43 indicates the openness, potentially, of the Court of Justice to the use of subsequent practice in the interpretation of an agreement. Now, one further footnote, if I may, which is that the court will not apply that approach in the context of the interpretation of the EU treaties themselves, and that is clear. So I don't want to overemphasize the importance of that paragraph 43 in indicating a willingness to use subsequent practice. The court, I think, is mighty hesitant about doing so, but it is open to it.
Could you just give us again, I'm afraid I didn't get down the reference to the...
My apologies.
Not at all.
It's case C43292.
Thank you very much.
Anastasio.
Yep.
I hope I'm pronouncing that correctly. If I may proceed then to some of the other issues that I wanted to spend more time on, and that's the issue of the explainer document. My Lord, 3 issues arose yesterday as to this document. The first was its origins. The second was what involvement the European Commission had, if any, in its production. And the third is the legal status of the explainer document. My Lords, in our submissions, the bottom line is, and I'll attempt to justify my bottom line in a moment, the bottom line is that the explainer document is no public relations puff or a mere statement of policy. It's a considered explanation of the government's intention in implementing and understanding the scope of what became Article 2, presented, it's true, as a public-facing document designed to give the general public an understanding of the non-diminution commitment under Article 2, but one that had been agreed with the 2 commissions and the European Commission. So, crucially, it's also clearly to be regarded as highly relevant in our submission for the purposes of interpreting Article 2. Following the approach mandated by the Vienna Convention on the Law of Treaties, in particular Article 31(2)A and 31(2)B. We can turn that up, my Lord. That's at 10861. But I won't, if you're satisfied, I'll continue with the point. And if necessary, we can return to the text. It would, I also submit, my Lord, it would undoubtedly play a significant role in any future international arbitration proceedings under Article 170 of the Withdrawal Agreement, which is, again for your note, at 10563, that might follow this court's judgment. My Lords, both the ECNI and the Northern Ireland Human Rights Commission were involved in the process that led to the explainer document. I asked the commission, my commission, overnight to do a trawl of its files in order to assist the court in addressing each of these 3 issues. The ECNI has now done so, and I'm now in a position to set out in a preliminary manner the ECNI's understanding of the process leading to the explainer document. Now, I say in a preliminary manner, my Lord, because the Commission is, of course, conscious not only of the duty of candour as a public authority, but also of its responsibilities to this court to present a fully accurate picture to this court. And while I'm confident that what I'm about to say is accurate, it may not be fully complete given the time that was taken. And I've asked the Equality Commission, therefore, to make sure that we shall be in a position to present as complete a picture as possible by the end of this week. And I mention that, therefore, to indicate that what I'll intend to do with the Court's permission is set out orally to you today on these 3 issues, Each of the points I make is supported with documentary evidence. If the court permits, and I'm highly conscious of my Lord's earlier point that you will not accept a speaking note, in this case, my Lord, it's not a speaking note I'm proposing. What I'm suggesting that the court might wish to do is that my intention would be to set out in writing for the court a full explanation based on a more complete trawl of the ECNI files, accompanied by the documentary support by the end of this week.
So your case is looking at 31(2)(a) and B. So you're focusing on the definition of context, not arguing that it is a subsequent practice.
I'm arguing both, my lords. If I may, I'll come to the...
Well, you referred to 31(2)(a) and B.
Indeed, and that's the primary submission.
Yes, thank you.
I should say, my lords, that one of the documents relied on is an in-confidence document from the government. And the Commission also wishes to give the NIO fair notice, and I've already mentioned this to Mr. McLennan, that it will be relying on this document to the court, if the court permits, us to provide the note that I'm proposing. Before you decide, my lord, may I indicate briefly what has emerged?
Yes, certainly.
So the evolution of the explainer document, which, as you know, is at 11290, is intimately linked to negotiations on the establishment of what's called the dedicated mechanism provided for in Article 2. And you'll find Article 2, by this time you must be fairly familiar with it, at 10751. You will see in Article 2.1, this is 10751, my lord, that the last sentence, the last clause of Article 2.1 refers to the establishment of dedicated mechanisms to implement Article 2.1. Now, the draft withdrawal agreement of the 19th of March 2018, so way earlier on in this convoluted process that all of us remember too well, the withdrawal agreement, the draft withdrawal agreement of the 19th of March, included the same language as what is now Article 2.1, including the phrase, and shall implement this paragraph through dedicated mechanisms. So in practice, therefore, the Article 2.1 was effectively already agreed in principle by the 19th of March 2018. And this draft is the same as that was agreed subsequently and is now before you in Article 2. The drafting of Article 2 did not change during the period of the negotiations. The number changed, but not the draft. So the question of forming the dedicated mechanism was a critical part of the attempt by the government to reassure a somewhat sceptical European Commission that the UK government was acting in good faith to establish an enforcement mechanism for Article 2. The Equality and Human Rights Commissions received a detailed proposal from the government on the 18th of September 2018. So following the agreement on the original draft of Article 2, in confidence for discussion by commissioners. The proposal was that the ECNI and the Human Rights Commission together would form the dedicated mechanism envisaged in Article 2. That was the purpose of the proposal. So that a dedicated mechanism would happen was agreed effectively. Obviously, nothing is agreed until everything is agreed, as we well know in treaty negotiations, but in terms of the basic understanding, Article 2 was essentially agreed, but what would constitute the dedicated mechanism was not agreed by that stage. And so the question was, what is to be the dedicated mechanism? Now, this proposal that was set out by the government on the 18th of September 2018, as I say, in confidence, is a critical document, we suggest, for understanding the purpose and intention behind the explainer document and its status. It shows, we submit, that the explainer document was the culmination of a long period of negotiation, and that the direct effect, for example, of Article 2 was clearly intended. My Lords, what's particularly striking about this proposal is how it mirrors what subsequently became the explainer document. There are 6 particularly striking provisions in these proposals of the 18th of September 2018. First, all rights, safeguards and equality provisions mentioned in the famous chapter of the Belfast Good Friday Agreement would be in scope of the dedicated mechanism. All the rights, safeguards and equality provisions would be in scope, provided that they are enforceable rights in Northern Ireland at the end of the implementation period, the point that Lord Reid mentioned earlier on, and insofar as they may be affected by the UK's withdrawal from the EU. Second, the government recognised...
No, not at all. Just to interrupt, but I'm sorry. But a point that keeps coming up is people talk about rights being affected by withdrawal from the EU.
Yes, ma'am.
Now, that could have 2 quite different connotations. One is that the impact of exit is to affect the right. The other is that as a consequence of exit, at some point in the future, there might be a law introduced affecting rights which could not have been introduced if we had remained part of the EU.
In the UK.
Yeah, I mean, there are 2 rather different senses of causation.
Indeed. Our submission, my Lord, is that essentially the test is a but-for test.
Right.
If but-for the European Union and the UK departing from each other, this right would have been required, as it were, by EU law, then it must remain so. The second point, my Lord, if I may, that the government recognised was the important supporting framework that particular elements of EU law provided for the anti-discrimination commitments set out in the relevant chapter. So that recognised a particular emphasis on the anti-discrimination provisions. The government had agreed with the European Commission that Annex 1 would contain those provisions of union law specifically relating to protection against discrimination. And I emphasise in agreement with the European Commission. My Lord.
No, not at all. Sorry.
Third point, my Lord, is the government recognised also that there may well be other EU instruments that are not specifically connected with protection from discrimination or don't have an anti-discrimination treaty base and thus would not be listed in Annex 1 that also support the rights in the Belfast Agreement chapter. And the government in this paper considered that those instruments, insofar as they've been implemented in Northern Ireland, again, your point, my Lord, Lord Reid, would be relevant to that commitment. Fourth, it was the government's understanding, again from discussions with the European Commission, that the no diminution commitment in relation to the acquis in Annex 1, unlike the broader no diminution commitment, was not intended to represent a snapshot of the level of protection available in Northern Ireland at the end of the implementation period. Rather, the government believed that the intention was for the no diminution commitment as it related to Annex 1 to include an element of keeping pace with the future developments in anti-discrimination acquis at the European Union level. So this refers back obviously to the discussion yesterday about the question of keeping pace and the application of Article 13.3 of the protocol.
So the commitment of the no diminution commitment would be static in relation to other rights, but dynamic in relation to anti-discrimination.
At least those provisions.
The ones in Annex 1.
Exactly.
Okay.
Thank you, Lord. The fifth point that emerges from the document is that to the extent that a substantive right in the Charter of Fundamental Rights was relevant to a right in the Rights, Safeguards and Equality of Opportunity chapter, that Belfast Good Friday Agreement right could not be diminished as a result of the UK leaving the EU. So in other words, to the extent that there was a charter right that was relevant to the Belfast Agreement right, that also could not be diminished. So recognising a particular function for the Charter of Fundamental Rights in this context. Sixth, my lord, and here we come to the nub of the direct effect point that has been exercising the court. Recourse to effective remedies for individuals, I stress the point, recourse to effective remedies for individuals would include the existing routes to enforce substantive and equality rights throughout the UK, through the UK domestic courts. In parentheses...
Could you repeat that, please? This is,
my apologies.
Would include...
Well, I was going to say, my lord, that that would include the disapplication remedy, of course, because that was an existing...
No, could you repeat what you said?
My apologies, my lord. Recourse to effective remedies for individuals would include the existing routes to enforce substantive human and equality rights through the UK domestic courts.
And that bit's a quote, is that right? Or?
It is a quote, my lord. The government also confirmed to the commissions that it was its intention to ensure that individuals would be able to enforce their rights under the Article 1 commitment directly before the domestic courts. In particular, the commissions would be empowered to give assistance to individuals to bring challenges against the government to achieve redress before the courts. And those powers that were indicated as early as September 2018, those powers, of course, are subsequently enacted in the 2020 Act, amending the Northern Ireland Act 1998. In particular, sections 78C, which gives the commissions the power to, for example, intervene in cases, which is why I'm able to be here today, but also to initiate own initiative investigations. But the important article for our purposes, my lord, if I may, is section 78D of the Northern Ireland Act as it now is. And that is the provision that allows the Commission to assist individuals who are taking cases under Article 2. My lords, if this all sounds familiar, it's because all of these elements found their way into the explainer document, often using exactly the same language. What's clear from the proposal of the 18th of September is how all these elements were clearly part of the negotiations with the European Commission. And only after having satisfied the European Commission on them, that contributed to the successful overall outcome of the negotiations. By the way, I should say the sections that I mentioned, the particularly relevant one, section 78D, is at 5225. My Lords, the 18th of September proposal itself makes clear that it had raised these issues at EU level by the UK government. The government's proposal to the commissions also stated specifically that the UK government would need to seek final agreement on the overall framework of the mechanism with the European Commission as part of the negotiations on the draft protocol as a whole. Once agreement was reached, the government intended to flesh out the remaining operational details of the mechanism in consultation with the Irish government, the devolved administrations in Northern Ireland, and the commissions, the Human Rights Commission and the Equality Commission. My Lord, I'm conscious of the time. I have a little bit further to go. May I beg your indulgence?
Yes, yes.
My Lords, to ensure that there was sufficient clarity and certainty on the role and functions of the dedicated mechanism, and once the government had reached final agreement with the European Commission on the entirety of the withdrawal agreement, the government further envisaged in this paper issuing a public document that would explain the Article 2 commitment for the public and how it would be implemented. And the government intended, as it subsequently did, to work with the Human Rights Commission and the Equality Commission on the content of this document. And the government expected that as part of their existing educational and awareness raising functions, they would jointly or separately communicate this new commitment to the public. This became the explainer document. My Lords, the explainer document was published, as you know, on the 7th of August 2020, some 6 months after the withdrawal agreement took effect. My Lords, it is striking that this document and the 2018 document that I've referred to are both entirely consistent with the text of both the withdrawal agreement, the Windsor Framework, and the 2020 Act, in particular the powers of the commissions, which presuppose direct effect. In other words, there would not be a power to give assistance to individuals to take cases under Article 2 if there was not direct effect. My Lords, it's also consistent with other contemporaneous statements in and out of Parliament by government representatives. The letter from the NIO Minister Robin Walker that Mr. Larkin previously referred to, which embarrassingly was sent to me wearing a different hat, if I may put it that way, was sent on the 26th of February 2020, less than a month after the withdrawal agreement and the 2020 Act came into force. And that's to be found at 1068. And it refers directly to direct effect. There was subsequently a statement by another Northern Ireland Office Minister, Lord Duncan of Springbank, to the House of Lords, made on the 28th of January, 2020, so somewhat before the letter that I referred to. And you'll find that at 11121, so 11.121 to 11.122. My Lords, I'm happy to turn it up, but I would prefer not to delay things. You'll find in that a really quite clear statement that reflects the explainer document. Both these statements are entirely consistent with our understanding of the text of Article 2, with the explainer document itself, and with the 2018 proposals. My Lords, at this point, may I, having sketched out what these documents contain, may I renew my earlier proposal. If the Court permits, I would set out in writing a full explanation based on the more complete trawl of the ECNI files, accompanied by the documentary support for which I've just said by the end of this week. In concluding, my Lords, I'm grateful for your tolerance. I should emphasise that we continue to rely on our complete written case, and that's at 236, which we submit directly addresses many of the issues raised by your Lordships. We anticipated that there would be likely to be only a short opportunity to present oral arguments, but we commend the entire written case to your Lordship. My Lords, unless I can assist further with my gratitude for your tolerance, that completes my oral submissions on behalf of the Equality Commission.
May I just ask for one reference? One reference, if I may, Mr. McCrudden, the letter of the 26th of February 2020. Yeah.
The reference to that is at 1068.
Thank you.
1068.
Sorry, 1068.
Yeah, I think we've got it 1068. Yeah, thank you. Thank you very much indeed, Mr. McCrudden. I think you had better provide your document to the appellants in the first instance.
Yes,
in principle, we would like to have it. And if other parties have any corrections to make to it, then so be it. But if there is confidential material, the appellants had better consider what their position is in relation to that. Obviously, we can't take material that isn't being shared with everybody.
Indeed, my Lord. That's part of you'll understand that's part of my hesitation in disclosing the documents in the first place.
Exactly. So see if you can sort matters out with the appellant.
I'm grateful.
Thank you very much. Mrs. Straw.
My Lords, I represent the Human Rights Commission alongside Ms Hart. In my 15 minutes, I'd like to focus on the question of direct effect of Article 2.1 of the Windsor Framework. Article 4 of the Withdrawal Agreement notes that a person can rely directly on a provision contained or referred to in the agreement. Article 2.1 is contained in the agreement, and so, as Dr. McLennan said, the critical question is whether Article 2.1 has direct effect under the conditions in union law. Could you please turn to page 194 of the main bundle? This is part of our written case, and in paragraphs 18 to 31 we set out a series of cases from the European Court which explain in some detail the conditions for direct effect of an international agreement under union law. I'd like to pick up a few of them. On paragraph 18 is the quote from Demirel, the Demirel test that Dr. McLennan has already referred to. I'd like to emphasise just one word in that, which is contains. So, regard being had to its wording and purpose and nature of the agreement itself, the provision contains a clear and precise obligation which is not subject in its implementation and effects to the adoption of any subsequent measures. So it's sufficient that a part of the agreement is a clear and precise obligation. It's not necessary that the whole provision is itself clear and precise. The Demirel test has been applied in a number of subsequent cases, which we summarise, and one of those is over the page in paragraph 22, the case of Akdas. This concerned the Turkey Association Agreement after it had been implemented by rules made by the Association Council. And one of those rules was decision 3/80. Within which there's Article 6, which is quoted at the bottom of the page, and I'd invite you to read that, please. Now, that was found to be directly effective, and the key reasons are over the page in paragraph 23, so paragraphs 68 and 69 of the decision. And again, I'd be grateful if you could please read that. So we say that the focus of the analysis of the European Court is the question as to whether there's a clear and unconditional obligation of result, which they held there was, namely the prohibition on a reduction of the listed benefits by reason that the person is in Turkey or another member state. The court didn't go on to ask whether the category of benefits which was subject to that obligation of result, namely the listed benefits, was itself precise and unconditional. So it didn't look into whether the legislation from the member state was unconditional, for example. It was sufficient that the obligation of result was clear and precise. And we say that that approach is applied in a number of other cases, which we set out. One of those is a little further down the page in paragraph 26 of our written case. It's called Weiler-Grupper. Could we go, please, to the judgment itself in that case, which is in the same bundle, page 10401. At the bottom of the page there, this is Article 10 of Decision 180 under the Turkish Association Agreement. And this article was found to be directly effective. It says, the member states of the community shall, as regards remuneration and other conditions of work, grant Turkish workers duly registered as belonging to their labour forces treatment involving no discrimination on the basis of nationality between them and community workers. Now, pausing there, it uses the language, the member state shall grant, which mirrors, we say, the language in Article 2.1 of the Windsor Framework, so the UK shall ensure. Dr. McLennan placed weight on that language and suggested that it demonstrated the provision was merely programmatic. But we can see this article was found to have direct effect despite using analogous language. And the same is true in respect of a number of the other articles found to have direct effect, which we refer to. So the case of Condover in paragraph 27 of our written case, the case of Van Gent, they use equivalent language. To see the decision in this case, could you please turn on to page 10408. So this is a section where they analyse the direct effect of Article 10.1, and in paragraph 58, the court notes, referring to Article 10.1, that rule of equal treatment lays down a precise obligation of result. No further implementing measures are required. And then please go forward 2 pages, 10410, paragraph 66. This is the punchline. Article 10.1 establishes in the field of working conditions and remuneration a clear and unconditional principle which is sufficiently practical to be applied by national courts. And again, we say the focus is on whether there's a clear and unconditional obligation of result. Having found that there is, the court didn't go on to consider whether the category which is subject to that result, in other words, the field of working conditions and remuneration, was itself clear and unconditional. It's important to note that in this case, as in a number of the other cases we cite, that category wasn't defined in the association agreement itself or in any of the decisions under it. It was an undefined category, and it may be said that it lacks complete clarity or precision. But it was enough that there was firstly a clear obligation of result, and secondly that the principle is sufficiently practical, the words used here, to be applied by a national court. Similar words have been used in some of the other authorities we cite. Condover is one of them in paragraph 27 of our written case, which uses the word sufficiently operational to be applied by a national court. Could you go back, please, to our written case? So it's page 197 of the same bundle. And in paragraph 27, that refers to the case of Condover and the words that I've just quoted. So it's a precise and unconditional principle which is sufficiently operational to be applied by a national court. So then, in summary of these cases, the approach of the European Court is firstly to ask whether there's a clear and unconditional obligation of result. If so, it's not necessary to go on and ask whether the category that's subject to that result is itself clear and unconditional, providing that it's sufficiently operational to be applied by a national court. And that's led the European Court to find a number of provisions had direct effect, even when the underlying category, so the category of rights, wasn't defined and lacked some clarity. And another example is the case of CIBA, which is in paragraph 28 of our written submissions, where the category in question was the field of social security. Now, that wasn't defined on the association agreement, and it lacked complete clarity and precision, and yet the provision was found to have direct effect. Well, applying that analysis here, we say that Article 2.1 of the Windsor Framework does have direct effect. It contains a precise obligation of result. That is, that the UK shall ensure that there be no diminution of the relevant rights that results from withdrawal from the Union. It bears similarities to the provisions that were found to have direct effect that we cite. Given that there is a clear and precise obligation of result, it's not necessary for the category that's subject to it, so here the RSEO, itself to be precise and unconditional. It's enough that it's sufficiently operational, sufficiently practical to be applied by a national court. And we say that the RSEO is sufficiently operational to be applied. A national court is perfectly capable of identifying the rights that fall within it and the rights that don't. My Lords, just to address a couple of the points raised by the appellant about the direct effect of Article 2.1. Firstly, Sir James suggested that there would be a radical change arising from our approach. We say that's not correct. The approach we and the respondents put forward merely preserves the status quo. So it merely preserves the legal effect of a narrow category of EU law that was in place prior to our withdrawal from the Union, namely on the 31st of December 2020, which also falls within the RSEO. And that's because, as the President noted, Article 2.1 only preserves, only prevents a diminution that results from withdrawal from the Union. In particular, in a challenge to legislation like this, The Court is only concerned with a category of EU law rights which took primacy over legislation here on the 31st of December 2020, so directly effective EU law rights, which also fall within the RSEO. And all it does is preserves the effect of those as it was on that date. The respondents argued, Dr. McLennan argued, that there were two indicators that Article 2.1 doesn't have direct effect. So the first of them was the absence of the CJEU's jurisdiction from Article 12 of the Windsor Framework. And the second was the existence of the Specialist Committee. And we say that's incorrect. They're not indicators that Article 2.1 doesn't have direct effect. The first point is the government's concession that Article 2.1 does have direct effect in respect of certain matters. So certain parts of the Annex 1 directive, race and religious discrimination may also come within it. And so that shows that both of these two factors can't deprive, or don't deprive, Article 2.1 of direct effect. So far as the existence of the specialised committee is concerned, the European Court has, on a number of occasions, decided that a provision has direct effect, notwithstanding the existence of an equivalent body. And there's a helpful quote at page 211 of the bundle. I'd be grateful if you could turn to that, please. This is the case of Simutenkov, which was equivalent to the Wala-Grippa provision. So Article 23 of an association agreement with Russia prohibited discrimination on the basis of working conditions and remuneration. And there was in existence a cooperation council which performed a similar role to the specialised committee, so facilitating the implementation of the agreement. And the European Court held that notwithstanding the existence of that committee, the Article 23 nevertheless had direct effect. And I'd be grateful if you could just read that paragraph there for the reasons.
Is this paragraph 66 or where is it?
It's, I'm sorry, yeah, it is paragraph 66, and the quote at the end of that paragraph, which is from the judgment in Simutenkov, paragraph 25 of Simutenkov.
Yes, thank you.
My Lords, in my final minute, I'd just like to make two final points, if I may. Firstly, Dr. McLennan relied on three cases on the facts in respect of Article 2.1. So they were Demirel, the Slovakian Brown Bear case, and Clone and Anboard, where direct effect wasn't established. And we say that none of those help him for the same reason, that all of them were entirely subject in their implementation and effect to subsequent measures being adopted. So all of them were subject to rules being created by either the Association Council or the local, the national government. And then the final point, my Lords, is that's leaving Article 2.1 to one side and just about the European Convention on Human Rights. The veterans movement raised new points about immunities. The Human Rights Commission supports Mr. Bunting's submissions about that. We understand that the Ombudsman and Amnesty agree with the Court of Appeal's position on that. Your Lordships raised the case of Gribben in the United Kingdom. I think the key point about Gribben is that it doesn't alter any of the underlying principles, the principles that are well established, for example, in Ramsahai, Jordan, updated more recently, and which Mr. Bunting has explained. I think that's the end of my time, my Lords, unless there's anything further.
Thank you very much indeed, Mr. Straw.
The central constitutional issue in this case is the concept of legal certainty in the rule of law. It's clear that that's why the question of direct effect is so critical. The law needs to be clear, and that's because it operates as a legislative competence mechanism in this context, not just on the Northern Ireland Assembly, but also on the Westminster Parliament. And we can see that because in this case, 11 provisions of the Legacy Act were disapplied before 9 of them had even been commenced. The same is true of the Illegal Migration Act. 12 provisions of that Act were disapplied on the same rationale before they had been commenced. So, in effect, we have an arrangement which operates in the same way that the provisions in the Northern Ireland Act do for the Northern Ireland Assembly. These provisions operate to prevent Parliament bringing the laws into force. And that's why the threshold for legal certainty requires to be very scrupulously considered. It's also the case that this effect arises through the operation of international agreement. And again, the tools we use to assess legal certainty, the EU used to assess legal certainty, are heightened in respect of international agreements because they are, in their form, giving effect to political compromises. And the Belfast Agreement is a classic paradigm example of that. It is a mixture of constructive ambiguity, aspiration, prospective thinking, and here and there precision. And it's exactly the kind of international text against which one has to apply the Demerol test. The case, as it has developed, has, we say, brought into very sharp focus the question of which rights are to be given legal effect by Article 4.1 of the Withdrawal Agreement. It now seems to be almost common case that the RSEO part of the agreement, which is the operative provision in Article 2.1, and that which is engaged by Article 4.1, the RSEO part, it is accepted by the Northern Ireland Court of Appeal and is accepted by the respondent as being insufficiently precise to give rise to direct effects. And that's paragraph 84 of the Court of Appeal judgment. It's the response Mr. Larkin gave to Lord Hodge yesterday. The consequences that flow from that, we say, must be addressed. And the consequences that flow is that you cannot have direct effect arising from those provisions. To avoid that inevitable consequence, the arguments are developed on the basis that there is something else in play here, a container or a box or a category which somehow or other encapsulates sufficiently clear norms to be applied so as to strike down acts of the Westminster Parliament and to impede the Northern Ireland Assembly in enacting laws and to chill the development of policy. But the question remains unanswered, and we had hoped for an answer from the Equality Commission or the Human Rights Commission. What's in the box? What's in the container? What's in the basket of rights? Because one has to answer that question in order to give effect to the provision in the manner that's been contended for. And you've heard no answer. Moreover, you can see that there are even internal inconsistencies in the arguments that are developed in the case. In the written case of the respondents, you'll see this, you don't need to go to it, page 115, there's the contention that the civil rights in the RSEO chapter include convention rights. That position was departed from yesterday. There's a difference of opinion between the respondent and the commissions in terms of the concept of dynamic alignment, how it's engaged, and whether or not and what impact it actually has. We don't need to resolve those difficulties. It's sufficient to identify the fact that they exist, because that, aligned with the fact that the RSEO chapter is not sufficiently precise, cuts against any possibility of direct effect. If there cannot be agreement on those concepts, there is no possibility of having a norm with the capacity to disapply acts of the Sovereign Parliament. Nor do arguments about subsequent practice assist, we say. The materials relied upon are decidedly thin. The fact of the Northern Ireland Act being amended, we say, is a function of the agreement. The explainer document, you will see from its final paragraph, was clearly embryonic, thinking aloud on the part of the government, with further to follow. The letter to the junior
Mr. McGleenan, embryonic thinking allowed. I mean, it's been explained to us that it was the subject of detailed negotiation.
Well, my Lord, this material, the evidence has been given to the court, which I haven't seen. I haven't seen the confidential letters. I don't know the context of any of that. What I rely on is the last paragraph of the explainer letter itself. It says this is our initial consideration. There will be further to follow. And there is no more to follow. So that's how the position was described. The document itself is replete with difficulties itself, but we don't need to go into that.
No, you said in your opening speech you'd come back to the document, and you didn't. But you've only a limited time, so I won't.
Yes. That's as far as I want to go with the document. I'll draw attention to the last paragraph. I do want to go to the letter to Mr. McCrudden, which is at 1068.
Of the main bundle of which
the appendix, my Lord. Part of this is quoted by the Court of Appeal, and you'll see the first substantive paragraph, which discusses again, and this is in early 2020, consideration of following various meetings and roundtable discussions, discusses again how the scheme will work. But the key point is in the last sentence of the indented paragraph. Having discussed the possibility of direct effect, the government position was the direct effect of individual provisions of the withdrawal agreement will be a matter for the courts.
So which page, sorry?
This is at 1068, my Lord, of the appendix bundle.
Right.
So it will be a matter for the court, which is the observation Lord Reid made yesterday in respect of the explainer document. It's all very interesting, but ultimately these questions will be a matter to be determined by the courts. And the question of whether individual provisions were given direct effect is one to be resolved in due course. That's been a consistent position of the government throughout. There's no difference in practice arising from that. That makes, we say, no difference on the key question. And in any event, the subsequent practice of the government has been to contest this litigation and the many other cases where the interpretation of scope found by the Court of Appeal has been opposed at every stage. So, in terms of the application of the agreement, which is the issue, we say these evidential materials, the explainer, the act, the letter, really take the matter no further forward. I'll have to reserve until I see what the evidence is, which has been commented upon. I haven't seen it. I think we'll have to examine that, and we'd need to see the entirety of the exchanges that have been between the Commission and the Government. But it may amount to nothing, we say, on the legal question. It may amount to nothing, because the heart of the matter remains what is the content of the rights given effect to by the RSEO part of the Belfast Agreement. And on that issue, the Court has no further clarity. Given the time, I'll pass over to Sir James.
On the human rights issues, I start very, very briefly with one extremely short point on the test to be applied, the Christian Institute Safe Access Zones test to be applied, and it appeared to be the core submission of Mr. Bunting that paragraph 14 of Safe Access Zones set out, as he put it, the rule and not the rationale. That appeared to be the core of the submission being made. If you go back to page 5918, you will see that my response to that characterization of paragraph 14 lies in the opening 5 words of paragraph 14 itself. The rationale of that approach, said Lord Reid, is that where, and so on, having already set out the rule itself in the previous paragraph, because the rule itself is the Christian Institute rule. So we respectfully submit that that is the rationale, and there is nothing in any later case restricting that or indicating that that rationale only applies, for example, to legislation that hasn't yet been commenced, or only applies in the context of devolution legislation. So that's all we have to say in response on the test to be applied by the courts. So far as Article 2 investigative is concerned, I wanted to make one initial point, and that relates to the Gribben case, Gribben and the United Kingdom case. Our submission is that the key paragraphs in Gribben are telling. The key paragraphs in Gribben are paragraphs 116 to 120, as you will recall. And what those paragraphs represent is effectively two things. First of all, they make absolutely clear that the test and the proper approach to Article 2 investigative is that approach that was highlighted by the Supreme Court in McQuillan from the Tunken Turkey case, paragraph 225, namely that it was not a correct approach to try and isolate the individual elements or criteria, as they're now characterized, that have been identified in the earlier case law and treat them all as separate and individual hurdles to be overcome. The correct approach was, as the Supreme Court concluded in McQuillan, that you look at it all together. And you have to look at it all together. And what that led to in McQuillan, and should lead to in this case, we respectfully submit, is an approach under which, save in relation to concerns that genuinely create incapability of satisfaction of those obligations, you shouldn't reach an answer to that question until the end of the process has happened. In other words, until the investigations prescribed by the legislation have in fact and actually been undertaken. The second importance of Gribben, we submit, is because it is and represents in effect a thorough Strasbourg sanction to the change of course that Parliament has taken in the 2023 Act. Parliament self-evidently, deliberately decided to move from the adversarial process with all of the inbuilt delays, challenges at every stage to every procedural decision and all of the rest of it that were characterised by the previous Northern Ireland inquest system examining cases flowing out of the Troubles. The deliberate move was to a much more inquisitorial model of the kind set up in the 2023 Act. And we respectfully submit that if one wanted any support, as it were, from Strasbourg for the justification for that basic and fundamental shift, you find it in Gribben. My Lords, next of kin, if I can turn to that, and the involvement of the next of kin. I don't want to take up a lot of time on this, but I do just want to remind you, that given the way in which my learned friend Mr. Bunting sought to present the relevant legislative provisions, I do just want to remind you of the way in which the Act is structured in a very basic sense. If you just go back, if you would, to the provisions of the Act, and I wanted to start with sections 9 and 10, because my learned friend Mr. Bunting started with section 11, which is really a follow-up provision to the basic provisions that you see in sections 9 and 10. Section 9 is at 527, and what I want to do in this exercise is very, very briefly to sketch the three stages that the Act envisages, including in particular with a focus on how the next of kin might be involved and what the Act does in relation to that. It's, if you will, a fuller answer to the answer that I gave in response to Lord Stephen's question to me at the outset. But I pick it up in section 9.
Sorry, page
5257.
5257.
I'm so sorry, 5257. That should take you to section 9.
It does.
And you will see that the process starts with a focus on the next of kin. A close family member of the deceased may request a review of a death. So 9 is about requests for reviews of deaths. Close family member is rule 1, as it were, and sub 1, sub 2, if there are no close family members, any family member can raise it. So they're involved from the very outset, and you get a similar provision, but this time relating to other harmful conduct. So in effect, 9 is about A2, 10 is about A3. And you see 10, the title of 10, requests for reviews of other harmful conduct forming part of the Troubles. And in this respect, paragraph 10.1, a person may request a review of other harmful conduct forming part of the troubles if that conduct caused the person to suffer serious physical or mental harm. So that's an open-ended category, not simply restricted to, but including the person who actually suffered the treatment or any family member. So that's section 9 and section 10, and then you get to section 11, which was the one that Mr. Bunting started with. And what section 11 does is to, as it were, make clear that the request that can be made is not just a request for an open-ended and general review, but a request that can include the asking, e.g. by family members in relation to a death, for answers to very particular cases that may have been troubling them. That's the function of section 11, C sub 1, for that purpose.
You couldn't just remind me where the obligation to comply with the Human Rights Act is?
Section 13.
13.
I'm going to come to that if I may.
Right, okay.
That's stage 1. That's the request for reviews. Stage 2 is the conduct of the investigation. And the key rule is the one to which I've just referred or reminded Lord Stevens of, page 5265. And it starts with the obligation to comply with the obligations in the HRA when exercising functions under this section. And you will see that the basic requirement.
So quite apart from the statutory provisions about the next of kin being involved, the Commission have to make sure that they comply with the procedural obligation under Article 2. Is that right? Yeah.
They do. That's the effect of section 13 sub 1.
Yeah.
But I do it in this stage, in this way, to emphasise that there's a beginning bit which involves the next of kin. There are then a series of rules about how the review gets conducted, and at the end we'll see there are a series of provisions about reports. So as far as the conduct of the review is concerned, 13.1 is important. 13.5 is also important. It imposes an obligation on the Commissioner to, quote, look into all the circumstances of the death or harmful conduct, including any troubles-related offences. So that's the basic jurisdictional provision. And surrounding that, one has all the powers that I went through in relation to the powers of the Commissioner to call for information, the duties imposed on government to provide information to ICRIR, and the powers that apply to ICRIR in relation to probing that evidence. All of those sit within the conduct of the review, and I'm not going to go back to them. I wanted, if I may, to jump to the end, which is the report stage. And the report stage you see in section 15 on page 5270. And you'll see again the chiming back to the death or other harmful conduct, chiming it back to the beginning of the process in sub 1, and then the duty to produce a final report on the findings of the review in accordance with this section. And you'll note what that includes specifically in sub 3 and sub 4, including, therefore, a response to questions and so on. But 15 is the basic obligation to produce the end product. And you will also bear in mind that there is a duty in section 17, see in particular section 17(2) A and B, not merely to provide a report, but to give the report to the person who requested the review, where it's been undertaken, e.g. under section 9, which is a family-driven request, as it were, to the Commissioner to review a death or the circumstances of a death. Not merely is there an obligation to produce the final report to the person who requested the review, but it's got to be published.
There's a procedure for consultation and representation made by the victim or family members under section 16.
Yes, my lord, I was going to go to that next, but that's the consultation provision. You're absolutely right. And you will recall in relation to that in relation to the sensitive information issue, which appear to lie at the heart of the disclosure issues. But you'll recall that in relation to that, there are a series of provisions which I will better just quickly pick up. There are a series of provisions that deal with reaction to a refusal to produce documentation if a request is made by ICRIR to the Secretary of State. And those are in Schedule 6. In particular, if you go forward in the bundle to 5464, paragraph 7, you will see that if it's proposed to disclose sensitive information in a final report, the Commissioner has got to notify the Secretary of State of the proposed disclosure in accordance with para 41A, which we looked at yesterday. And there is then a process which requires any affected report in that way, as it were, to include a statement by in the report itself of the Secretary of State's reasons for refusing to produce. So those are subject to provision to the families and to publication in the final report. And it's at that stage that you have the right of appeal. It's called an initial appeal. You'll see that at page 5466 in paragraph 9. There can be an appeal to the relevant court against the Secretary of State's decision not to permit the proposed disclosure in the affected report, 9.1. And the function there is to review the decision not to permit the proposed disclosure. And it's got to apply the principles of judicial review when doing that, C9.3. And if it decides that it doesn't pass muster in that respect, the court has the power to quash the Secretary of State's decision. And that would include, no doubt, a judicial review on Human Rights Act grounds, which might rely on Section 13.1 itself. So that's the basic process that is set up.
And to make it absolutely clear, the Secretary of State in making that decision would have to take into account, as a public authority, his obligation to have a proper investigation under Article 2. And therefore, he has to, in fact, carry out appellants. Yeah.
I agree. Yeah. And on that basis, therefore, in relation to next of kin involvement, the reliance upon Armeen, which you'll recall Mr. Bunting placed considerable reliance upon, simply doesn't assist. You cannot, I respectfully submit, possibly conclude at this stage that there would be the sort of next of kin defects, if I'm allowed to put it that way, that were identified by the House of Lords in Armeen at paragraphs 36 and 37 of that case. I don't invite you to turn it up again, that's page 6565 in the bundle. But there's no earthly reason to suppose that those would be replicated. Indeed, on the contrary, you will have seen that at all stages, from review to report, next of kin involvement, and indeed, I would add, the publicity that is attended upon and the accountability benefits that flow from the publicity in relation to the end result when the report is ultimately produced, including a specific requirement to set out, for example, reasons why the Secretary of State was not prepared to allow for sensitive material to be produced into the public. So that's the first thing to say about Armeen. Absolutely no analogy whatever to the position that you have under this Act, still less the certainty that will be required before you could conclude that the Act was incapable of delivering proper next of kin involvement with all the fluidity that that ingredient or criteria itself contains. But secondly, you will see that the reference to minimum standards that Mr. Bunting repeatedly makes takes him nowhere, because those minimum standards, as he put them, don't help. The question is, what are they and how do they work? And we know from Tunk and we know from McQuillan and we know from Gribben that the way in which they work is as criteria which all feed in to condition the answer to the overarching question, which is whether or not, in fact, not in theory or in abstract, but in fact, the investigation that has been undertaken has been an effective one. So that's what we say about next of kin. In relation, finally, then, to disclosure, the essential submission that was being made orally was that the disclosure provisions are unsatisfactory because too narrow. I've confronted that, and I confronted that in opening, and I've reminded you of the way in which the provisions on the disclosure of the report and the publication of the report and that process works. But we respectfully submit that the disclosure provisions in the Act are more than sufficient to conform to whatever the criteria set out by Strasbourg require. They cannot possibly, again, be characterised as being incapable of delivering a satisfactory level of disclosure, particularly having regard to the fact that the Act, as you will recall, contains a specific obligation on government to produce everything, in effect, into the closed process that is ICRIR. And I do just want to remind you, if I may, of the Committee of Ministers' proposals and thinking in relation to that you were taken to yesterday. The thesis appeared from Mr. Bunting to be that the Committee of Ministers' documentation illustrated or confirmed some fundamental objection from the Committee of Ministers, which you will be required to take into account under Section 2(1)(d) of the Human Rights Act, against the sort of provisions and set-up on disclosure that we have in the 2023 Act. And my respectful submission is that they do no such thing. The height of the Committee of Ministers' documentation, when one traces it back again, I'm going to go to one document only, at the height of those documents is to indicate that the Committee of Ministers was concerned that all relevant documentation should go to ICRIR. That was its core concern, and that was specifically given effect to in the legislation itself by the creation of the specific duty to do exactly that thing. The rest of it, in relation to involvement with families and so on, was either a call for further information or a recitation in the relative terms that we saw in the criteria under Article 2 investigative, or simply a recitation in that broad language of the need sufficiently to involve the next of kin, one can say, insofar as necessary to protect their legitimate interests, which was the mantra from Jordan. The one document I wanted to draw attention to...
I think you better just give us the reference.
Yes, my Lord, of course.
Because we're going to have to hear Mr. Larkin in reply as well.
Well, my Lord, you may or you may not do, because he has a right of reply in relation to the charter matter.
Yes.
And my learned friend took no time at all in responding, dealing with that charter matter. He didn't say anything beyond what he'd said in opening. Right. So I'm only going to be another couple of minutes anyway, if I may. But I'm not unduly rushing on that basis, if I can put it that way. My Lord, the document I wanted to remind you of is in the appendix bundle. Again, so it's the appendix rather than the main bundle. And the page I want, just to remind you of the bit that my learned friend Mr. Bunting took you to, is paragraph 9 at the top of page 3340. I'm sure you'll remember he took you to that. Yes. And you'll recall from the earlier documents all the Committee of Ministers' consideration of the need to provide evidence to ECHR. The paragraph I just wanted to remind you of was the previous one. Back a page, if you do a page up click on your computers, back a page to 3339, paragraph 8. So the committee there notes, in relation to the general measures, with interest, the amendments to the bill tabled by the government since the last examination of the cases, which in particular strengthen the participation of the next of kin of victims in public scrutiny in the work of the ICRR. So we remind you of that provision. My learned friend Mr. Bunting's core argument in relation to disclosure appeared to be to try and link it with independence and to say, well, there's a problem with independence because the Secretary of State may be inveigled into these inquiries or into civil claims. He is notionally and formally and constitutionally a defendant and so on. We simply remind you of the test in relation to independence for the purpose of Article 2. that was the matter that was considered very clearly and specifically in McQuillan by the Supreme Court, paragraphs 193 and following. I don't intend to go back to those. I simply remind you both of the head note to McQuillan, don't turn it up now, but it's at 7736, which we respectfully submit accurately records the nature of the independence requirement under Article 2, drawing on, in relation to the paragraphs in the Supreme Court's judgment, paragraph 195, which itself was based on Tunk. And what that paragraph emphasised was that the focus under Article 2 was, as it was put, on the independence of the investigation in its entirety, rather than as an abstract assessment. And they noted, again in paragraph 195, that's the Supreme Court noted again in 195, that the principle in question was of, quote, unacceptable hierarchical or institutional connection. And the adjective we respectfully submit is both deliberate and important. So, for example, if there were to be difficulties because there were personal links and so on, then one can see there would be a serious issue with that. But in this analysis, this conception of independence for Article 2 investigative, that idea of independence and the judgment about it is intricately intertwined with the connected issue of the practical effectiveness of the investigation. So if there are concerns that they haven't done things, they haven't called a policeman because he was a friend or was a relative, or they haven't gone and got documents, that might cause a serious concern. But those ideas of effectiveness and independence are intimately intertwined. And what that leads to is the setting of one's face, if I can put it that way, against the idea that independence is problematic for the purpose of Article 2 just because it involves government. And all the references to the Secretary of State that were made by my learned friend were to the Secretary of State as government. One can test it in this way. Almost every public inquiry that there's ever been has been set up with an Article 2 or an Article 3 element involved in it, has focused at some point and to some degree on the government, on the government's responsibility, on whether the system of regulation that underpinned fire and safety hazards for Grenfell, for example, all of those inquiries inevitably come back to the system of regulation and the responsibility of government for it. But under the Inquiries Act 2005, it necessarily starts with the appointment and setting up of the inquiry by the government. It is the minister who has to appoint the chair to the inquiry, and it is the minister who has to exercise the discretion to set up those matters. And not merely that, but under the Inquiries Act model, it is the minister who, as under the 2023 Act, necessarily has to be involved in making the primary judgments, CU3 and all that line of cases, in making the primary judgments about whether or not disclosure, not to the inquirer, ICRIR, but outwards to the public and all the next of kin, would be problematic from the perspective of national security. Who else could do that? Who else would be appropriate to do that? Who else has the democratic responsibility and the institutional competence to do that? So we respectfully submit that there is no difficulty with the Secretary of State being involved at that point in that way. And focusing very specifically on the Act that we have here, you've seen the way in which the provisions work. This isn't, as I put it in opening, this isn't a position in which the Secretary of State is given, as it were, an untethered and broad-ranging discretion. The Secretary of State has to operate in accordance with the detailed system of rules and definitions and procedures that are specifically and in detail laid down by the Act. So there are definitions of sensitive information. There are definitions of information that might be prejudicial, and by the way also protected international relations. But those are definitions laid down by Parliament. There are then processes for an exchange, as it were, of views, a mandatory exchange of views between ICRIR and the Secretary of State. And there are all those provisions that you saw in relation to the production of the report, so that to the extent that it can be, the reasons for holding on to that sensitivity are made overt and are put into the public domain so people understand why certain categories of document cannot be given. So in conclusion, we submit, what is at stake in these appeals in relation to the human rights arguments is fundamentally the choice that was made by Parliament, no doubt with the sort of thoughts that were motivating the European Court of Human Rights to say what it did in Gribben, to change the model. And to do so, we invite the court finally to note, precisely to move from the system which the respondents to this appeal advocate is a sine qua non of an effective investigation, namely full-blown adversarial process, representation by lawyers of choice, legal aid, cross-examination, full-blown adversarial. Parliament deliberately decided to move from that model, and it is that which is at the core of the attack that is made by the respondents, and we respectfully submit it has no basis.
Thank you very much, Sir James.
No answer to the charter point, so I have no right to reply.
Well, we are sincerely grateful to Council for their assistance. As you know, but those sitting in the public benches won't, we've got about 13,500 pages of documents in front of us, and having Council skillfully guide us through the most important documents has been extremely helpful. We'll take time now to consider the submissions that we've heard and to give you our decision as soon as we can. The Court will adjourn.